Thank you very much, Ms. Zinani, for the legal opinion. Members, that is the legal opinion from the Parliament Legal Services. Any comments, any takers, questions or comments? Honorable Breitenbach.
Thank you, Chair. Good morning and good morning to everybody. I would like to ask Ms. Zenani to just please go into a little more detail about how she envisages the process working if one member of the panel or the committee does not participate in 2 of the interviews because she's recusing herself, but participates in the rest. How will you weigh, how will you fairly, objectively and effectively weigh the performance of the candidates as a whole, when the approach has always been that whoever participates on the panel must be there from the beginning to the end? You can't join halfway or leave halfway and then still want to, participate, simply because you'll be incapable of forming an overall view of the proceedings. So I would be interested to hear how she thinks that scenario could possibly work. Thank you, Chair.
Thank you. Can I check if there are any other questions? I think that seems to be the only question so far. Ms. Zenani?
Thank you, Chair. I am not sure if it would not be for the committee then to manage that process because, as we have already stated, this is what the law says, and in our view, this the facts presented call for a recusal, and really, I am not sure then if it would be up to, with respect to legal services, to then make a call on how the process should go forward if Advocate Mkhwebane has not recused herself. But from our side, this is the legal position that we have presented.
Any further questions? Honorable Breitenbach, I think it's an important question, but I think it's academic now because she participated throughout the process. So she did not recuse herself for the duration of those 2 candidates. But the issue before us is that Advocate Mkhwebane participated throughout the process. I think that is the issue before us now. Any further questions?
Yes, Chair.
Honorable Ngola?
Chair, I'm not quite sure if Honorable Breitenbach's question covers mine, because when I'm listening to the opinion, it only starts advising from the interview process and the processes that we may have undergone before the interviews, which some is a short listing where Honorable Mkhwebane fully participated. So I don't know what implication does that have in the entire process. If the legal advisor can enlighten us with that regard. Thank you.
Thank you. Ms. Zenani?
Chair, I'm not sure if I should respond now because I see there's another hand.
I think on my side, I don't see any hands. I think if Committee Secretary, you can assist me with the hands. I don't see anything on my side.
Chair, Mr. Ganji's hand is up.
Okay, it's Honorable Janji, and who else?
That's the only one so far.
Okay, thanks. Honorable Janji?
Morning, Chair. No, thank you, Chair. No, I'd raised it a bit earlier, but I was struggling because Ms. Zenani was sharing a screen, so she had blocked in terms of that, and now I'm able to speak. It's just a brief one, Chair, on the 2 issues raised by members, in addition to yourself. I was going to come in after Ms. Zenani, but maybe just to start with the point that you have closed. on Ms. Breitenbach, Honorable Breitenbach, because her question is critical, but I think her question is applicable in a point system in an interview. Because the point system where when you adopt that, it means that from the start to the end, you've got to have the full participation of those members, because if you don't, your point system gets to be affected. That vis-a-vis a deliberation system, which we do as a committee, then can make it very different, because in sometimes you can have a member who would not even ask a question in an interview. And be covered by other members, but will participate in a deliberation. So it does affect it in a way when it is not a point system where you score basically. And then my second point, Chair, related to Honorable Ngola's question, because I also had that. But if you read Rule 30, and the critical part in Rule 30 says, and I'm going to read that, is that he or she must, at the commencement of the engagement on the matter by the forum, immediately declare that interest in accordance with the code of conduct contained in the schedule to the joint rules and comply with the other provisions of the code. The point here, Chair, is that the commencement of this matter would not have been in the interview. When we shortlisted, that would have been the commencement of the matter. And in the shortlisting, that's when you have the actual names of the people that we're talking about. That's the commencement, and it says you must declare at that point. Advocate Mkhwebane did not declare, but she did not just not declare or kept quiet. Advocate Mkhwebane would have supported a suggestion, a proposal that Honorable Ngola made on Tibele. She would have supported that name. And that's, therefore, if you have to talk about a factory fault and where things started, that's the commencement of the point. I think the legal advisor can assist, but that's my take, Chair, when we get to the deliberations. Thank you.
Thank you very much. I don't see any further questions. Ms. Senani, would you like to comment on those issues?
Thank you, Chair. I think Honorable Ganji has covered me, but perhaps just to add, Honorable Ngola was asking the implications of the legal advice, considering that the process did not just start at the interviews. I think, as I indicated earlier, ours is to give a legal position to the matter. And as Honorable Ganji correctly points out, the commencement would have been at the stage of the shortlisting or the stage of the initiation of the process. And as I said, this is the legal position, and it is then up to the committee to decide on whether or not the process should be recognized in its entirety, or what then to become of the process. Thanks, Chair.
Thank you very much. But your contention is that the process as it stands now, with the facts before you, the process is open to litigation by any of the affected parties can litigate.
Chair, it is our view that it is, with the facts presented, it is open to litigation. And perhaps may I just add that I think processes like that in general, are always open to litigation, which may come from either direction.
Okay. Thank you very much, members. What is the way forward? I think we have had an opportunity to ask questions. What is the way forward now? Or can we deliberate based on the legal opinion that we have received? Committee Secretary, can you assist me with the hands?
Chair, we have got no takers at the moment.
So what do we do with the legal opinion? Honorable Mola? Honorable Breitenbach, in that order.
Thanks, Chair. I think, Chair, let's take the legal opinion as it is, and let's take it as that it forms the basis of us deciding on how then do we move with the process from here. I think let's accept the legal opinion and thank the legal services unit for having assisted us until thus far. I think let's accept it and take it as a document that is going to form the basis of how we decide on proceeding with the process. I think I want to suggest that, Chair. Thank you.
Thank you. Honorable Breitenbach.
Thank you, Chair. I'm sure that you will understand that I'm doing my very best to not state the glaringly obvious, but I do suggest that we accept the legal opinion. Thank you, Chair.
Thank you very much, Honorable Mkhwebane.
Good morning, Chairperson. Good morning, members.
Honorable Mkhwebane, we can't hear you.
Hello? Am I not audible?
No, we can't hear you.
I'm talking.
You are not audible.
I'm not. Don't hear me.
No, your voice is too faint. We can't hear you.
Because I am objecting to the legal opinion. Or must I switch off and come back?
No, you're fine now. You can proceed.
I wanted to say, Chairperson, I thought I would be asked before the members can decide what happens to the legal opinion. The issue here, Chairperson, is that I dispute the legal opinion based on facts which are not properly captured. Yes, the question is, when was Ms. Breitenbach was supposed to object to my refusal? And secondly, the issue I've raised in during our deliberations that when the candidates were presenting or appeared before the committee, I then indicated, I hear what Mr. Jantjies is saying, that I should have, I supported Mr. Ngola's suggestion of Mr. Taylor. And indeed, I didn't indicate anything because as part of the collective, I wanted us to move forward with the candidates. And secondly, the candidates themselves were asked during the interview whether they've got any objection to my participation. I think even Mr. Tibeila was even asked whether he has benefited anything from me or am I benefiting anything from him. The pro bono provision has no financial interest between the two parties. And as well, I indicated, which I still don't agree with, the legal opinion, the conclusion which the legal advisor has decided on is very much not well researched and very much biased, if I may say, that I must recuse myself due to a perceived bias based on personal relationships or perceived financial benefits. I'm disputing it based on the case of the Minister of Justice and Constitutional Development versus Noete. The court emphasized that a mere apprehension of bias is not sufficient ground for recusal. Rather, actual bias must be proven. Secondly, the case of the DA versus the public protector and others, the court held that recusal should be based on concrete evidence of bias rather than speculative perceptions. The judgment highlighted the importance of a fair and impartial decision-making process requiring a high threshold for proving bias. Moreover, in the Economic Freedom Fighters versus the Speaker of the National Assembly, the court reiterated the principle that recusal should only be mandated in cases where there is a clear evidence of a conflict of interest that may prejudice the fairness of the proceedings. Therefore, while the opinion which has been presented raises concern about perceived bias, the legal precedent in these cases suggests that a mere perception of bias may not be sufficient to warrant recusal. So concrete evidence of actual bias must be established to justify the recusal. And further, Chairperson, the report of the Chapter 9 of the Section 194 Committee is a subject of review as we speak. As you will understand or know that I've taken the public protector on review for the refusal to pay the gratuity. Therefore, that whole process, it links to the issue of the outcomes of the Section 194 Committee. So that matter is before a court. And in conclusion, Chairperson, I would indicate that the committee have accepted the report of the two committee members. Possibly the committee will decide to do that, but then on my side, I'm objecting to the adoption of this legal opinion because firstly, it's also based on information which is still a subject of dispute before the courts. As you know that I was never given an opportunity to present my side of the story on such charges before the Section 194 Committee. So I will end by saying, Chairperson, the issue of deciding who will be the next Deputy Public Protector, it's a committee decision. It's not my decision. And again, no matter which candidate I would want to be appointed, if the committee with the current practice which is happening in the deliberations in the National Assembly, the majority most of the time rules. So I will end it there.
Thank you very much, Honorable Breitenbach, followed by Honorable Janji and then Honorable Ngola. Is Honorable Breitenbach, Honorable Ngola, Honorable Janji in that order?
Thank you, Chair. I only have 2 points to raise. Ms. Mkhwebane continues to raise the issue of when should the DA have raised this issue? Well, the DA isn't the party with the conflict. Ms. Mkhwebane is the person who has the conflict. She's the person who knows the two people in question, the rest of us don't. So the only time we can raise it is when we're in possession of the CVs, having read them, and seeing that she arrives on the morning to do the interviews or that's when we raised it. So who raised it when is completely irrelevant. She is the person who has the conflict and she should have raised it right at the beginning. She failed to do so. So it's no point harping on that issue. It's patently incorrect. Secondly, Ms. Mkhwebane has referred to a variety of cases. The newest case on the matter is a case that was delivered on the 20th of March while we were busy with these issues. It's a decision of the Supreme Court of Appeal. It's the matter of SAP, SE, and Systems Application Consultants and others. And the full bench of the Appellate Division found as follows. Let me just find the end here a moment. Found as follows, and I'll read it for you. The only question is whether there is a reasonable apprehension of bias. If there is, cadit quaestia. And for those who are not Latin speakers, that means the question falls away. The case is closed, no matter what effect this might have on the particular proceedings. So that has always been the law. This is an affirmation of that law. And I see that nobody's referring to that case, and I'm a little concerned that neither Mr. Mkhwebane nor Mr. Nani actually referred to it. Thank you.
Thank you, Honorable Ngola.
Thank you very much, Chair. Chair Advocate Mkhwebane keeps on referring to concrete evidence. And in the same vein, she does not dispute the fact that Advocate Tebele is representing her in the African Court for Human and People's Rights. She is not disputing that. That is the first concrete evidence. The second, Chair, she does not dispute that there has been a labor issue between her and Ms. Mokgaladi. And that does not make it a perception. She is not disputing, Chair, that Ms. Mokgaladi took her to court on the basis of labor victimization and all those things. Let's leave Section 194. We're speaking about the relationship of Advocate Mkhwebane and Ms. Mokgaladi at PPSA. Now, from what she's saying, there is still no dispute to the fact that these 2 points are actually true. As she refers to concrete evidence, she equally does not dispute the fact that these 2 issues are not perceptions. They are concrete facts of what happened and what is happening currently. So I find the rejection, her rejection of the legal opinion so mischievous from where I'm seated, because the facts that are a genesis of why we are here are not in dispute. So the issue whether she's the sole determinant of the process and all that, it has passed, because even the legal opinion does actually venture into that fact. That is actually irrelevant, that you are not the sole determinant of the process. So I think, Chair, let's continue and accept the legal opinion as it is. Thank you very much.
Thank you very much, Honorable Chanche.
No, thank you, Chair. Thank you for the opportunity. Maybe so that we avoid this period of April used to be a period in my rural setup where there would be what was called the Boswell circus. So to avoid a merry-go-round in April, we might need to just be focused and more specific. For example, I think the first issue, Chair, that you must just assist us with, and you have posed that question, and maybe we need to make it fuller on record in terms of the decision of the committee, is whether as a committee we accept and agree on record with this legal advice. And so you've got to have to put that so that it's fully made, it's recorded as such, and we note whatever objection that there is. So far, we have got one objection. Firstly, on the legal opinion, because once we move from that premise, then there are a number of other issues that will trigger from that. I wouldn't want us to mix things, in that process. So that would be really my first suggestion I make, so that you guide us in that and we assist you in chairing. Otherwise, as I indicated earlier, it would be a Boswell circus if we don't do that. We've been here before on some of these issues. That really is going to be my first point, Chair. And the point, the issues for me are not complicated, are not complex. The legal opinion gives us a lot of facts on issues, because if it relies on Rule 30, Rule 30 is very. I'm not even going into the other case laws at all. I'm trying to save my time. Just Rule 30 on its own is very specific and very focused in terms of what is required of a member to do. And in this case, Advocate Mkhwebane failed to declare. And it's really a big point, because you can't drive a bakkie, Chair. And I'm going to use that analogy, that this committee, it was a bakkie, and then we stopped in a particular bus stop. We picked up all of these candidates that we shortlisted. And when they got onto the bakkie, you said nothing. We drove with them, okay? And talk with them, and in the process of the start of the interview, you said you were going to declare. When you needed to declare at the bus stop, when we got these people onto the bakkie. So Advocate Mkhwebane must just help us and be honest, and I think the committee we must take a decision on this, because it's clear it might not go anywhere. It's clear that she failed to declare, and for me, that's the starting point and the end of it. Not that other issues are not important in the process. I'm not even getting into the interview, and because of that, I mean, for example, she makes the point about the DA. Maybe I would have had an issue with the DA, not in terms of raising their point, but it's immaterial. Because my issue I had with the DA was we had a 30-minute session in the morning, if you remember, before we started the interview, and the DA did not raise anything. That's an issue I would have had with the DA. But whether they raise it at that point or when the start of the interview, it's really immaterial. Their own kind of an objection. I think, Chair, for example, even the issue that she's raising about Section 194, that she's challenging that. The report of Section 194 stands as, that's why she's here in Parliament as part of a member of a party. It's because Section 194 is standing. The fact that she's challenging, there's no interdict, there's no legal impediment on that report. Otherwise, if that report was not having a standing, she would still be a public project that concluded in October her own term. So she must not even get into that point. But therefore, what I would want us to suggest, Chair, once we make those first 2 points of making that decision and noting the objection, is for us to get into, therefore, having accepted the legal opinion, what then are we saying in terms of the deliberations? We now need to deliberate about our own work so that we remove the first hurdle of the legal. So I don't want to proceed further before perhaps we just finalize that, Chair, but I would want us to go to that point and not waste our time on some of the arguments that are being made, which are irrelevant, which ignore the factual information that is in front of us. And I think it looks to be very deliberate in that way, Chair. I will pause there for now, but I just wanted to make that so that you are able to drive us into getting into the deliberations about our interviewing process. What do we do? What has been placed in front of us are 2 options from the legal advice, that whether Advocate Mkhwebane recuses herself or or she recuses herself in terms of those 2 candidates, and there might be even a third option from ourselves as a committee of what to do when we get to the deliberations. So at this point, I want us to pass that mark. Sorry for being long.
No, thank you very much, Comrade Janji. I think the next round, it will be to say what needs to be done, but let me finish the line of hands that I have Honorable Horn and Honorable Mkhwebane. Then after that, we must move to a way forward. Honorable Horn.
Yeah, thank you, Chair. Good morning to you and colleagues. Yeah, look, Chair, unfortunately, and maybe it is because we are in the run-up to elections, it would seem that petty politics is threatening a constructive discussion of this matter. I'm in full agreement with the Honorable Breitenbach that that it is astounding that there could be an argument from Ms. Mkhwebane that all of this is really the fault of the DA, and then it would even seem that she finds some sympathy from the Honorable Jantjie, who says his issue with the DA is that we should have raised this earlier. Well, that in the same vein, we then maybe have to ask, why did all of this escape the ANC? I mean, it is astounding that there could be an argument that we're sitting with this mess because the DA was not proactive enough. Yeah, but let me leave it there. As I say, I think we must start getting constructive, and in that sense, I want to add my voice to those who have said that we are faced now with this one option only, and that is to firstly accept the legal opinion. I think it is quite clear. It is dealing with the relevant issues. I don't expect Ms. Mkhwebane to accept the legal opinion, which, of course, just once again, to an extent, will underscore the fact that she is not able to deal with this in a detached manner without looking at it from the perspective of her own personal interests. But Chair, for the sake of progress, I think we must get to a point where we take a formal decision to accept the legal opinion and then put forward, let's say, some options around how to then take the matter of selecting a candidate to be nominated as Deputy Public Protector forward. Thank you.
Thank you, Honorable Mkhwebane.
Chairperson, I totally disagree with what Mr. Jantjie is saying. In the first place, the very same particular committee don't come here and behave as if you are organized and you have processes in place. In institutions or where I myself, as the public protector, during the shortlisting, there are forms which we complete where members will declare. Not to say I was hiding anything, and I never even nominated. I supported for the benefit of the committee. The very same Jantjie, Mr. Jantjie came here. You said you know Mr. Chipanyane. You are the only one who said that. And even when we were interviewing the candidates for the Human Rights Commission, you indicated that you know this candidate. And again, one will have to go back to those shortlisting and check, did you openly even say you know those candidates? Chipanyane, when we were shortlisting, did you ever say you also are declaring that you know Chipanyane? So, and this process, the way it was done, indeed, the legal opinion, the way it was crafted, at the end of the day, it was going to be very fair to sit down and get all the facts right as the legal, or the person who's providing the legal opinion, given that, yes, she was given this time and she did the legal opinion, which indeed, I wouldn't agree with it. Hence, I'm still saying, Chairperson, that the very same fact that this was conducted the way it's conducted and the way now, because anyway, ANC and DA is the same thing, you are agreeing on this legal opinion. And when I'm saying the matter is before court, you can't come and say, I can't raise this particular matter. A person like me who worked as the public protector, who had employees under my administration and who dealt with issues of discipline. The very same candidate who you are saying, I went to the labor court and the matter was still before court, for your information. The acting public protector removed that matter because a higher court might have reached a different conclusion. And it was not a dismissal. Hence, I don't agree with the labor court when they were saying I've already concluded. Because I was saying, why shouldn't you be dismissed based on the evidence which is before us? And the very same candidate, having accepted the wrongdoing, and even in his affidavit saying, I would even take a more harsher punishment because of the betrayal and the dishonesty I did by hiding the evidence and the Rule 53 records from the executive. So I don't think it's a question of presenting it as if I am hiding anything. I came here objectively. I'm participating as part of the collective, and I at no way wouldn't be objective in this particular instance. So, Mr. Mola, you are saying there is evidence. I agree, and indeed I acknowledge that Mr. Tipeila indeed is representing me before the AU. The issue here is to prove the actual conflict and the actual bias. If I would be arguing, and I mean, even now, we are arguing on this particular issue without even realizing what is the view of my decision per these candidates, because the deliberations on their performance and how they have conducted themselves, we haven't reached there. But now we are rushing to accept this particular legal opinion, which I'm saying, actually, I don't even agree with, because there's various cases in Ms. Breitenbach we are raising. There is a court judgment which I didn't pick it up when I was taking my own issues, but I'm also still insisting that the issue here at hand is that we have to work as a collective, objectively, forget about, as Mr. Horn is saying, politicking and all those, but then to ensure that we get a candidate who will then benefit the South Africans, who will assist the public protector to protect the public. So I think I will just end there, Chairperson, and it's your decision, and hence I said earlier, you are the majority. Definitely, you'll decide according to how you want to decide. And the very same candidate, Ms. Mukhaladi, never had any objection or any reservation about my being present or interviewing her during the proceedings. So it's fine. Thank you.
No, thank you very much, members. Thank you for the inputs.